tell you right now. So we dealt with minimum contacts and International Shoe Company and all steps. That's pretty much where we left off, right? Okay. Yeah, so I can tell you right now, we're gonna push your test one back 1 week. So instead of test one being next week, it will be on the 26th. Okay, which means, of course, the next test will also be pushed back, but we'll deal with that when we get to it. Okay, so what I wanna do tonight is get as close as we possibly can to finishing up chapter 2. And then you'll notice that your first test, which will, and I'll try to remember to post it on Moodle, that I'm gonna push the test back a week. The first test will cover chapters 1 through 3. So what I anticipate is that we get pretty close to finishing up 2 tonight. We'll put the finishing touches on chapter 2 next week. Chapter 3 is very brief. I don't have more than about 20 minutes to talk to you, or 20 minutes worth of material to talk to you about in chapter 3. And then we'll move into chapter 4 next week, but that won't be on the test. Remember, just to give you a couple of weeks heads up at this point, you need to bring your own Scantrons for the test and pencil with an eraser. I do not have Scantrons at my disposal, so if you come without one, I will not be able to help you out. You will have to depend on the kindness of strangers, your classmates, to see if you can rustle one up. So try to remember to get them. Blue ones or green ones, either ones work, but make sure they're the rectangular pages. I'm saying rectangular, the big like 8.5 by 11 pages. Some people come in sometimes with these truly rectangular, like vertical ones that are about that wide and that long. Those will not work because the testing services computers will not be able to grade those. And your test will be graded by the testing services computer. So make sure you get regular size. If they're the same size as this, 8.5 by 11, but they're in this kind of landscape view, okay? So the blue or the green will be just fine. Remember also that it's 60 multiple choice questions, and I put up for you on our Moodle site sample multiple choice questions from chapters 1, 2, and 3 from that study guide that I had mentioned to you all. The publisher used to publish, it doesn't anymore. So I just scan and upload the questions, the multiple choice questions, and the answers for each chapter on my own. So those are there for you for a couple of reasons. It gives you some idea of what the test questions will look like. They're multiple choice. But if you look at those sample questions, you'll see that they usually have a relatively brief, like factual situation laid out in the paragraph, and then you're asked a question and asked to pick the best answer from the 4 or 5 choices listed. My strong recommendation is that you keep those multiple choice questions until you are satisfied that you know the material, and then use them to self-test, to test yourself on the material before you come in to take your first test. The answers are all there for you. And then the other thing, if you remember, the beauty of those questions is that I take at least 3 from each one of the chapters, 3 of the questions that you will have already seen and already know the correct answer to if you use the sample questions. I take 3 from each of those chapters at least and put them on the test. So 3 or 4 questions from 3 chapters, that's 9 to 12 questions out of 60. That's a nice little chunk of questions you'll already have seen the question, and you should already know the correct answer to, if you're working with multiple choice.
From the sample questions from the book or the study guide?
No, the study guide, the ones I uploaded on Moodle, question.
We would use our book to answer those, but do we ever get to know if our answer is correct or not?
On the multiple choice ones, yeah, I gave you the answers as well.
Oh, okay.
Yeah. The study guide, has the questions and the answers, and so all of that's been uploaded for you. And the good thing about the answers usually is, they explain why the correct choice is the correct choice and why the other ones are not. So you can really kind of learn a lot from, working those and just getting comfortable with that sort of style of question. Yeah.
How many questions did you say was gonna be on the test again?
60.
60 multiple choice questions, 1 point each. And just so you know, I don't like, ring the bell and say, okay, all papers have to be turned in. I will give you as much time as you need, but I will also tell you that about 90% of the class will be finished with the test by between 7 and 7:15, so an hour to an hour and 15 minutes. I start class up at 7:30, so anybody who needs additional time past 7:15, I just take you out in the hallway, we find a comfortable little spot. Well, I can't vouch for the comfort, but we'll find you a chair, hopefully, and you can stay out there and finish your test and then come on back into class when you're done with it, okay? So, I say that particularly for international students or anybody else whose, first language is not English. But even if that's not the case, if you're just somebody who likes to take your time on tests, I'll give you the time, okay? So you don't need to really fret about that. But I am gonna go forward with class at about 7:30, so we'll have class for about an hour and 15, and the test will be about an hour and 15, okay? Any questions about any of that? All right, y'all, so here we go back into chapter 2. I talked about the Supreme Court, how many members they have and all that stuff. Yeah, 9 members and how they're appointed. Y'all remember that, did I? No. Okay. All right. We talked about the case of Marbury versus Madison and the power of judicial review, right? Supreme Court in that 1803 case said, yeah, I remember having that conversation. Okay, so I'm not sure if we also did subject matter jurisdiction, in rem jurisdiction. I think I started off with that. Ooh, sorry.
Was the Marbury versus Madison 1803 or 1802?
Marbury versus Madison is 1803.
Okay.
Okay, so what we talked about was that the courts have to have jurisdiction over the subject matter of the lawsuit. So again, I think the example I gave you is, if you're trying to get a divorce, you're filing a petition for divorce, you wouldn't file that petition in, an appellate court, you wouldn't file that petition in a bankruptcy court, because bankruptcy courts only have jurisdiction over subject matter involving bankruptcy, okay? So the court has to have the authority to hear a case involving whatever the factual legal issues are. That's what we mean by subject matter. In rem jurisdiction, anybody remember what that is? Okay, that's where the case in front of the court involves property, either a building or land. And what I said was, the courts of the state where that property is located always have jurisdiction over a case involving that property. So think of it this way, a lot of jurisdiction has to do with geographical boundaries in a way. Okay, so the question is, most state courts have jurisdiction over all kinds of things that happen within that state's geographical boundaries, all right? So obviously, if the lawsuit in front of a judge involves a piece of property located within that state, then the courts of that state always have the authority to hear that case. There may be another state that has authority too, under some different rules, But in rem jurisdiction simply means the courts of a state have jurisdiction to hear cases involving property located within that state. And then we started talking about, personal jurisdiction, and we did the non-resident defendant, we did International Shoe Company versus State of Washington, minimum contacts being the test for when can the courts of one state force a defendant who resides in another state to come to the first state and defend a suit. So when do the courts of one state have personal jurisdiction over a non-resident defendant? And the answer is, it came to us through International Shoe Company, 1945 decision, Supreme Court, when that out-of-state defendant has at least minimum contacts with the state in which he has been sued. If that defendant, that out-of-state defendant, has no connection whatsoever to the state where he's been sued, then that state's courts are not gonna have jurisdiction over him. And he might be served with the lawsuit, but his lawyer's gonna come in and get that lawsuit thrown out, saying, you can't sue him in Louisiana. He has no connection to the state of Louisiana.
And that connection could be something just as small as him, just passing through, or?
Well, obviously, the better, like everything in law, minimum contacts, what does it mean? Doesn't have an absolutely precise meaning. It means generally what it says, that the defendant has to have some connection, some contact with the state where he's been sued, and they don't need to be like, he doesn't need to have lived here for 5 years or anything. It can be minimum. But the more connection, the more contact he has with the state, the more likely it is the courts of that state will have jurisdiction over it. So, some of the examples, if I didn't give you, I'll give you now. We talked about the Florida accident thing with a Louisiana and a Georgia defendant, parties. Again, any state is gonna have jurisdiction over a case that involves an accident that took place within that state's borders as well. So that's kind of a biggie then, obviously.
How do you establish contact or minimal contact? What represents minimal contact?
You have to show that he's got some connection to the state. It can be any number of things. Like I said, in the case of a lawsuit that involves an accident, the accident involved the defendant. The defendant lives out of state, but he was involved in this accident within a particular state. That's plenty enough contact for the courts of the state where the accident happened to have authority over the case, or the authority to hear the case. If it's a contract lawsuit and not a personal injury lawsuit like an accident, that one's a little bit tougher in this day and age because, people don't really necessarily have to get together face-to-face anymore to negotiate contracts, right? You don't even have to get face-to-face together in the same room to sign the same contract, right? People use duplicate originals and all that kind of stuff. So contracts ones are a little bit more difficult. It used to simply be, in the old days where people somebody had to travel to somebody's office to negotiate and sign the contract. So if the out-of-state defendant from Georgia came to Louisiana to my lawyer's office and sat down, or even if he was in there for 10 minutes just to read over the contract and then sign it, that is, again, plenty enough connection. It's brief. So that's what I meant when I said it's kind of on. So anybody who didn't catch the roll, come grab it up. I get into football mode. I cannot help myself. I'm going to say at halftime. I mean at the break. If I say halftime, just blow me off and know I mean at the break and not halftime. Okay. Anyway, so again, that's not a very big connection, but that's how it's decided. These days, it's really tougher on contracts. The good thing about most contracts these days is the parties to the contract will put in the contract itself, before they ever sign it, what state law is going to apply to interpreting the contract, and or what state's courts have the right to hear a case involved. So people are trying to handle it that way now. Obviously, if that's in the contract, then that's where the lawsuit lawsuit has to be filed. And then I had used the example of maybe, I don't know if I used the word a space heater or something. The product manufacturer who's in California who gets an order online from a customer in Louisiana, send me one of your space heater devices. It gets delivered to the customer in Louisiana, he plugs the sucker in and bursts into flames, he gets burned, he's got some property damage, some personal or bodily injury. The courts say even though that manufacturer has no retail outlets in Louisiana, never advertised like on TV in Louisiana, never made a pitch to get customers from Louisiana, the fact that that California manufacturer put a product into the stream of commerce, took some poor schmuck's hard-earned cash for that product, shipped him the product, and the product was defective and caused him injury, the courts say, the Supreme Court says, as a matter of law, we're going to say that as between the big manufacturer of the product and the poor little consumer that ordered the product innocently and it was bad and hurt him, who can most afford the inconvenience of traveling to the other one's state? That's going to be the big fat company, right? Obviously. So they can be forced to come to Louisiana and defend. And then we've already covered if there's any property, if the suit involves property and the property is located in the state. Short of that, it's a case-by-case determination by the courts as to whether an out-of-state defendant really does have enough connection to the state in which he's been sued to force him to come from his home state to the state where he's been sued and defend the suit. So there are a few rules that are almost what we call bright line rules, like the property rule and the defective product rule, but the rest of them, particularly in contracts, it can be a little iffy. And people slug this out in courts all the time. Okay, so I don't know if I mentioned this, but if the defendant, the out-of-state defendant that you're suing, if that is a corporation or an LLC, so you're a Louisiana plaintiff, you need to sue a corporation that was formed under the laws of Virginia. Corporations are actually citizens of two states, although most of the time the two states are going to be one and the same, and this is what I mean by that. Corporations are citizens of two states. The state where they file their articles of incorporation, so that's the document that you have to file with the Secretary of State's office in whatever state you decide to form your business in. You file articles of incorporation with the Secretary of State for that state. So you can sue a corporation in whatever state it filed its articles of incorporation. But you can also sue a corporation in whatever state it has its principal place of business located in. For small corporations, almost always, those are going to be one and the same, right? A small corporation that has maybe, I don't know, 5 directors, 5 shareholders, they probably filed their articles of incorporation in the same state where they have their main offices. That's what we mean by principal place of business. But there are many very large corporations that are either successor corporations to other large corporations that were formed 100 years ago, or they're large corporations in and of themselves. And a lot of those big guys file their articles of incorporation in one state in particular. Anybody know what was forever the favorite state of corporations? Delaware. That's exactly correct. So, for example, Freeport-McMoRan, local, we think of it as a local corporation. Freeport-McMoRan's a Delaware corporation because they filed their articles in Delaware. But their principal place of business is in Louisiana. Their main offices, to my knowledge, have always been in Louisiana. So if you have to sue Freeport-McMoRan, you can choose to sue them either in Louisiana or in Delaware. Delaware was the first state, or one of the very first states, that made sure that corporations that formed in Delaware paid no state income tax. All corporations have to pay federal income tax, right? Most of them have to also pay state income tax, depending on where they're located. So Louisiana, we charge corporations state income tax. They gotta pay the feds and they gotta pay the state. Delaware, no go. Delaware says, no, you're not, you come locate here, we want your business, come set up here, put our people to work, we ain't charging you any income tax on whatever you make. And there are many other advantageous laws in Delaware for corporations. They deliberately did that to attract companies to come for obvious reasons. There are jobs that go along with that, right? A lot of times. So, because we have a state income tax on corporations and we don't have any other particularly favorable laws that attract corporations, we have very few major corporations that have any operations or conduct any activities in the state of Louisiana. That's why we're so job poor all the time, especially when the oil and gas industry is down. We don't have a lot of alternatives here in terms of big employers. Yeah.
Is it the same situation with South Dakota? A lot of the credit card companies seem to be sending their junk mail from there.
It could be. I'm sure there's some advantageous law up there. Yeah, more than likely. I can tell you, it's kind of odd. There are a lot of like the state that's, for whatever reason, best known for franchise laws is it's one of the two M's, Minnesota or Michigan. I think it's Minnesota. So it kind of depends. Some states have legislatures that are out front on new developments in terms of business, and they get proactive and pass laws as a way of like saying, okay, this is a new big area, right, involving business, and we want people to come here and do their thing. So it kind of varies. But Delaware, it still has some of the most advantageous laws, but there are now many other states that also have eliminated state income tax on corporations for the same reason Delaware did, to try to attract people. Any other questions? All right. So corporations, again, can be sued. They are citizens, if you will, of two states, where their articles are filed and where they have their principal place of business. So to go back to Sonny's question about, and Gary, right, about how much is enough in terms of contact. There's an old case, not that old, from 1998, where the federal court in Ohio